Good morning. My name is Kathy Harward. I direct the Student Legal Services Office at CSU. I've been there for 10 years. And I guess I want to tell you a little bit about me so you know what kind of information you're going to get from me today. I have never been a landlord, so but I want to be very useful to you today, and I invite questions, so please, let me know if something we're talking about triggers a question for you. I'd much rather have this be a conversation and useful to you. Even though I've never been a landlord, I've done landlord-tenant law every day for the last 10 years because that's a huge part of the office work at CSU, as you can imagine. And, I have a lot of opinions about how it should be done. So it would help me to know how many of you rent to students. So quite a few of you. And how many of you manage more than 5 units? Okay, not too many. Of those, how many manage more than 10 units? 1, okay. It was my suspicion driving over here trying to anticipate who you might be that you probably aren't that sort of manager for a corporate-owned large complex. You all appear like you probably are more what I would consider more the smaller landlord, which thank you. I'm so grateful that you are in town. Probably the biggest beef that I have these days are with the corporate managed, out-of-state landlord, big complexes, and there's some huge problems with how they write their leases and how they treat the tenants, and that can get me pretty hot and bothered. Today I'm trying to be humble and I'm trying to be mellow, so I kind of vacillate between those two places. I don't like things that are unjust, and I will fight for that. But overall, in our office, and there are 3 other attorneys in the office at CSU with me, our approach is always to solve the problem. And we're not one-sided. We don't think just because we represent tenants only that tenants are always right or that we want to push some kind of solution like that. Usually it's somewhere in the middle, and to solve a problem, you have to look at things that way. So even though I'm not a landlord, I solve so many problems every day. Sometimes I go home and I say, I don't want to do this anymore. I've had every hour a new problem. I'll give you a quick example of the kind of stuff, and some of it is just the inexperience of youth, but it's complex lives, and I think you are like me in that you've signed up to be problem solvers, and I've signed up for it, so I can't complain at the end of a day when it's been case after case of my girlfriend took her car to the mechanics, they gave her a loaner, she gave me permission to drive that loaner to Vail to ski. I hit some ice, I hit a snowbank, I crashed the car. I don't have insurance, I didn't report it to the police. Some nice guy pulled me out of the ditch, I drove home. It's a month later, I'm trying to settle with the mechanic's office to pay them a fair value for the car. They want more than what's fair for the car. Girlfriend is getting tired of waiting on me, so she calls the sheriff and says I did a hit and run, so now I'm looking at a traffic criminal misdemeanor and a 12-point ticket, and that's just one case for the day. So you all are problem solvers, and I'm here to try to help you with the things I've learned over the last 10 years. So the handout I didn't have ready when they were making up these nice notebooks, and I want to confess humility because for years I've been complaining about bad leases that are small print, many pages. I don't like the Colorado Apartment Association lease, by the way. I'm sure some people use it. It's kind of been vetted through your agency. I hate it. It's not very readable. The student tenants don't understand it, and I would guess that many older tenants don't understand it either. So I've been railing for years against bad, complex leases, and I finally sat down and said, okay, I have got to be able to write a better one than we've ever used before and try to make it plain language. So I started, and I thought, okay, I'm going to use first person, second person. So you can see in the first line there that the parties I've defined as the landlord, we're going to name as I or me in the lease, and it also includes any agents that you authorize to act for you. Okay, so I want to spend a little bit of time on this. And I am happy to email an electronic version of this simple lease to Josh, or the support person Melanie has been, I think, emailing you in case you would like to have that in that version. But so I wrote it, and I've not seen anybody else write a first person, second person where you refer to tenants as you. I'm not sure it's any simpler, but I was hoping that it might be. So if we go through this a little bit, I think I can highlight some of the issues that you guys are facing, likely. On the first page, number 3, joint liability, I just want to make a quick comment about that. I would prefer landlords not have their leases have joint liability, but I find that most landlords want to put everybody into a group as tenants so that they self-manage each other. It's problematic for the tenant. It probably makes sense for you, probably. I mean, there are some landlords that like to have individual leases with their tenants. It would give you the flexibility if somebody is misbehaving to just go after the one. You could even file an eviction just after the one. I think people have a harder time thinking they can do that if everybody is jointly liable, because the contract puts them all in a pool of being all liable for everything. So you have to decide. But I get the business reason for putting everybody as a joint tenant. Then they have an incentive to manage each other, and you can go after the one with money, even though that person may not be the one at fault. And I'm not going to go verbatim through this. I just want to use it to highlight a couple of things. Security deposit. You can take up to 60 days. You can't take more than that under the security deposit statute for Colorado. If you don't put any day limit in there, then the default is that you have to return it within 1 month. And you need to send a written reconciliation, return the remainder of what should be owed, and if you don't and the tenant disputes that and sends you a 7-day demand letter and you don't send it back, what is owed in 7 days, then the tenant can get triple damages in court. So that triple damages should cause you to pause when you are, or the threat of triple damages, I think, should cause you to be careful not to overcharge. So an example from yesterday, I have a nephew that lives in Golden. He goes to School of Mines there, and he called me, and actually when you're 20 years old, you don't call, you text. So I get all these long texts from my nephew. Oh my goodness, our hot water heater went out on the weekend, and our landlord called the plumber on Sunday. We let the landlord know immediately because there's water all over. Landlord does the right thing, gets somebody in on Sunday, and then is telling the boys that he's going to charge them for the water heater and the plumber bill. And of course, I cite my nephew in my slow texting the statute and just kind of give him the language to tell the landlord that's not okay. And of course, the landlord immediately backs off. So I don't know why people do that. I really don't. It's not helpful, and anyway, you all know that's not the right thing. You can't charge for a water heater unless the boys were banging on it and, you know, turned it into some kind of a party bash thing, which they didn't. So I think you all know that you have, well, maybe you don't. The law says that the person responsible for repairs is how you define that in the lease. So you actually legally could say that the tenant is going to be responsible for all the repairs. You could try that. That's kind of old law. That's modified by a couple of other laws, including the rental housing standards for Fort Collins, which another speaker will talk to you in detail about, and the Colorado Warranty of Habitability, which is a statewide law that imposes minimal habitability requirements. And so those, in order to keep those up, you would be responsible for those repairs. But you could try to shift all the rest of the repairs over to the tenant. I don't advise that at all. My tenants, if they come to see me, would fight that based on the basic rule in the law under the security deposit statute that you can't charge for ordinary wear and tear. And you would have to, again, do what it takes to keep up the rental housing standards that are Fort Collins law if you're in Fort Collins, and the warranty of habitability requirements that are statewide. You can. So you can charge reasonable rates for putting the property back to the shape it was in, absent ordinary wear and tear. So if you gave the property to them clean, and you can have some evidence that they caused pet damage to the carpet or what have you, and you keep track of either your time or a cleaner's time that you contract with, you can charge that. The real crux of it, though, is how do you prove that it's their pet that caused the problem, for example. I want to make sure everybody knows that blacklight testing is bogus. We have a professor, a physics professor at CSU. He's the fellow that runs the Little Shop of Physics. He's got the wild hair, and Brian Jones, that's his name. And he's super smart and researched the whole thing. He urinated on carpet himself and ran blacklight over it. I actually have a kind of a document he created for us that it's very funny, but the science is good that blacklight tests don't work to prove pet urine, so don't waste your money on it. And so again, the problem is however do you document? That's probably the biggest issue we have in our office is students come in and say, I'm getting charged $2,000 or $3,000 over my security deposit. How can that be? It's like, well, do you have pictures? I try to tell students before they lease to do a narrated video from room to room to room, so you could do that as well. Documentation of the condition at move-in is the #1 way to protect yourself so you can justify whatever charges you're going to charge. If it's filthy, that's not ordinary wear and tear, so whatever cleaning, but the cleaners need to document too what they've done. I've seen lots of, it tends to be I guess I shouldn't generalize. I've had experience with the larger property managers where every cleaning bill looked exactly the same, and they managed 200 properties, different ones, not the large complexes, but actually 200 different homes. It's like something's fishy here, and you're going to have a little more trouble justifying it. But if you have your cleaners justify what they had to do, then I don't think there's any of our county court judges or our small claims court magistrate that would have any problem giving you that money or giving you that win. Doesn't mean it turns it into money. So the comment was that you might want to put what your hourly rate for cleaning charges will be in your lease so that you're not in court disputing it and somebody says, since you didn't put it in the lease, you can only charge minimum wage. I don't think most judges would do that. I think they would say, what's the prevailing rate for a house cleaner? But that's variable. So sure, you can put that in your lease. The issue with leases are I think once you have some experience, with your particular property and maybe the part of town you're in and the clientele you tend to have, like if you're near campus and you have a lot of students, you're going to have a lot of language in there about maybe noise violations and that kind of thing. You should definitely tailor your lease to fit the problems you've encountered before and put in as much detail as you think. But if you put everything in there, you're going to have a 30-page lease that is going to be kind of off-putting as well. But documenting the condition, yeah, that's super important. No, there's no 7-day limit. So for a tenant to be able to take advantage of that part of the security deposit statute that says if a tenant's going to sue you and wants to ask for triple damages for what you've wrongfully withheld, they have to send you a written letter at least 7 days before they sue. But they can sue up to a year for triple damages. They can actually sue up to 6 years for the straight return of whatever you withheld. I've never seen anybody do that after that much time. Nobody's going to have a reason. I think it would be done within a year, but it's not 7 days.
It's 7 days before they sue you.
before they sue you, they have to send you a letter, and as long as you cure the problem within that 7 days, then you can't be subject to the triple damages. Yeah, I don't think painting is ever going to be a time interval like 10 years, then that's a landlord charge to repaint. If the tenants, and I've had this case where the tenants threw a party and they threw out a box of markers and invited their party guests to just, mark up all the wall. Of course, that's beyond ordinary wear and tear, but it's not a particular year. And in the handout that's actually in your notebook, the yellow one, I do have a section in there where it basically says good bet, bad bet, and it comes from judges, and that is under number 5. And those are things that judges have said, it's a good bet that it's not ordinary wear and tear if there's a big grease stain in the middle of the carpet because they did something to their motorcycle in the middle of the living room. It's a good bet to charge them for red wine spills. It's a bad bet to charge them for the various lists there. And, every judge is different. So again, I think the better you document, the more likely you won't have trouble with that. You don't have to have a separate business. It all comes down to credibility if you're in court disputing it. So if you're saying that, your time was this many hours and you're charging $50 an hour, but you could have hired a cleaner for $20 an hour, but then there's, a contractor to do some patching of the drywall, and if you know how to do that, that probably carries a higher hourly. So when, it's what can you do to make it seem reasonable to the tenant so they don't dispute it? And then if they do dispute it, what can you have done so that our magistrate in small claims court or our county court judges, if you use a lawyer, can feel like they want to give it to you? So yeah, but yes, you can charge for your time. You don't have to create an LLC for yourself, a company for yourself, or anything like that. So if you look at the plain language lease that I gave you, I've got a paragraph called pre-agreed charges number 30. So if you want to always just charge carpet cleaning and rekeying, for example, or anything else, put it in there and highlight it. That would be a very good bet to charge something that's been pre-agreed to in the contract. The pet, yeah, let me talk a little bit about the pet thing is a huge problem. And if you haven't encountered it yet, I think the biggest part of the problem, part of it is the damage caused by the pets. So again, it goes back to, did you document how nice your unit was before the pets moved in? You allowed the pets, but that doesn't mean you allowed the scratching of the wood or the fraying of the carpet and that sort of thing. So again, you've got to have good documentation. I think nowadays the worst problem around pets for you all, and I have great sympathy for you, is that people have gotten the word that if they can qualify their animal as an assistance animal, not a service animal necessarily, like a seeing eye dog, but an assistance animal, comfort animal, then it's not a pet. You can't charge pet rent. You cannot charge a pet deposit. You can't charge pet fees. You can charge for damage done by the animal. And I know many people probably rightfully feel like it's being abused. And I have a neighbor who's a pilot that flies to Hong Kong all the time, and he says you can't believe what people bring on the plane under the auspices of that same thing. But it seems like a battle that I don't encourage you to fight. So I was on texting with my nephew yesterday, and also a different conversation with my neighbor whose daughter is wanting to have her landlord accept a comfort animal, a comfort dog, based on some diagnoses that she has. And this landlord, I can't tell you how much wasted time and drama and my time, which again, I don't mind. It's my job. I signed up to do this, so I can't complain. My neighbor's time, who's a doctor, his daughter's at CSU. So the issue is she has a doctor's letter that says what it has to say. It's not her dad, the doctor, who wrote it for her. She has her own independent doctor that says she has a diagnosis and condition that interferes with a major life function, and this animal will assist her. That's all she needs, and the landlord should back off. But he is wasting, it's just crazy because he says no, and he says, oh, now you're going to have to get a lawyer and talk to my lawyer. Well, the lawyer he's wanting to get involved knows nothing about landlord-tenant law. It's his buddy that's a personal injury lawyer in Denver who's spouting off stuff that's not true. So I have sympathy, but that's not a battle you should fight. You should accept it. You are entitled to get documentation. And actually, there's going to be a speaker on that, so I don't want to step on that information. You'll have an expert on that, but my just advice is don't fight what is absolute in the law right now. If you want to go change the legislation about it, you're going to have to deal at the federal level and the state level because we have laws at both levels. So that's a big battle that you may or may not have time to do, but document like crazy. So if this, like my neighbor's daughter, for her assistance animal, she got a puppy. So I think that's a little wacky, but the law doesn't say she can't have a puppy. So it would be your job to make sure you prove the condition before the puppy comes in so you can charge for all that damage. That would be where I would put my effort, not in creating all this weird pushback drama that's been going back and forth. Yeah, so the question is, no pet policy, how does that interact with these laws that we're talking about? And again, you will have an absolute expert on it at another time on the agenda, so re-ask that question. My understanding is, from them, I've talked to the regulators about it, DORA, Department of Regulatory Agencies, that's the state of Colorado government office that regulates it, and also HUD on the federal level. Those two offices share enforcement. And if the tenant isn't being treated right, all they have to do is call those two offices, and those investigators will, for free, help the tenant. They don't really help, they're neutral. They help the problem. They listen to both sides and see whether the law has been met. But the issue is they're not pets. So in this plain, my stab at a plain English lease, I say no pets. And I don't put anything in here to encourage the assistance animals, so I chose to leave that out. But if someone, going back to your question, the timing of it, the regulators say that a tenant can ask for an accommodation at any time. They have to provide what they need to provide under the law. They don't have to wait for this, in my example, this unreasonable landlord to quit doing all this drama. They can just move the dog in as long as they've gotten the ducks in a row. Okay, a bunch of questions on that, but remember, I'm not the expert on it, so again, fair housing laws say you can't discriminate based on a disability. If you have a legitimate reason for picking a different tenant over them, and you're willing to suffer the conflict over that if you get challenged on it, but the answer is you can't discriminate based on a disability, you can't discriminate based on someone having an assistance animal, but you may pick a different tenant for a legitimate reason and be ready to prove that later. If the tenant that you don't trust that you want to pass on falls into a protected category, let's say they are a minority color, they are from, they have a national origin, all those protected categories, you run the risk that they're going to file a complaint that you pass them over because of. And they may not, and you may get away with it. So, but again, raise it with the expert. I don't want to take over that content. So when the speaker on that topic is here, hopefully the speaker will distinguish, because it's true there's service animals and they can be used in certain public areas, but there are these laws that require a landlord to accommodate a non-service but a comfort or assistance animal. We have them, they're there, so you'll get all of that from the other speaker. So the question is, can you charge higher rent or require a lower deductible on the renter's insurance? And again, no, you can't treat it like, it's the fair housing laws that don't allow that. So I'm realizing I have a lot of important points I want to get to, so I'm just going to cut off the questions and try to hit on a couple of highlights. Number 7, utilities. You can't believe how many tenants don't really realize that electric and gas are separate, and they forget to pay one. And it goes to the point of take time with each tenant. And I have a list of good practices that are on the yellow handout. And that handout kind of weaves in with some of the things I wrote into the lease. So I'm not being linear here, and I hope that works for everybody's brains. But if you would take a little bit of time to educate tenants on the basics of utilities in Fort Collins, how you sign up, where you go, include the addresses in the lease, give them a little bit of basic housekeeping knowledge in your particular property. If the toilet is overflowing, student tenants have no idea that you can turn that little knob at the back. They don't know that. They don't know anything about the furnace. So I think it's crazy for landlords to put any of the repair responsibility on the tenant. So in this lease, my repair clause basically says tenants can make no repairs. Landlord will arrange repairs. Landlord will charge tenant if the repairs are due to misuse by the tenant. That's the law. You might as well state it the way the law is. There are so many leases that say it the wrong way, and you could never enforce those clauses. So mine, what I've attempted to do here is actually write it the way the law would require you to do it. And that's exactly how it is. I think we've kind of talked about most everything on page 1. On the back, 12 and 13, 14, 15, those are suggestions for you informing the tenant that the city of Fort Collins does enforce, they hand out noise tickets. Those are criminal tickets. They hand out nuisance tickets. Now we have a brand new ordinance called the Social Host Ordinance. So if your tenants are hosting parties and letting minors drink, they can get tickets. The number 15 there, illegal activity, when Zach talks about eviction, he will explain that certain breaches, certain illegal activity by a tenant can constitute the kind of breach that allows you to go straight to eviction. You don't have to give 3 days to cure. Most breaches, you have to give notice and the tenant gets 3 days to cure it. If they throw too loud of a party and you don't like it, you can give them a 3-day notice, but the party's over, you can't evict on that. But if they're, if there's cooking meth in your house, of course, that's a very dangerous, that comes under a substantial violation definition under our eviction statutes, so you can get somebody out without that 3-day notice to cure. So that's why I put that in this lease. I actually wrote this lease for landlords, but trying to make it as fair to tenants as I possibly could. So number 17 is kind of a pet peeve of mine because the landlord trade groups have started creating these bed bug addendums that try to shift the cost of bed bug treatment, pest control to the tenant. That's illegal most of the time. I don't know why that's happening and why landlord groups are doing that. The law comes under the warranty of habitability, which in the yellow handout, I have a whole bunch of material on that. It states that it is your job as landlords to do pest control unless the problem stems from misconduct by the tenant. It doesn't say conduct, misconduct. So in my lease, in this simple plain English lease, I've got a whole bed bug provision that says the landlord will charge the tenant if the problem is due to the tenant's misconduct. I quote the law exactly the way it is. It's going to be hard for you to prove that it was misconduct. So I added some language in there that, for example, bringing in a mattress that you got on the side of the curb is not okay. Bringing a used mattress from home where you don't suspect bed bugs is okay. You're still going to have a proof problem, and I would just ask you to stop threatening tenants that they have to pay for all bed bug treatment. Bed bugs aren't from dirt. They don't come from being dirty. They can come from a brand new pair of shoes that someone bought at the department store and brought home, and you don't know they're in there. It's a weird problem that has resurged in the last few years. We never had any problem for a long time. And so I think you have to build that into your business model as a potential cost that you might have to pay. And yeah, most landlord, Well, I only see the problems in my office, so every case about bed bugs that I see are landlords saying it's your problem, it's your problem, it's your problem to the tenant. And I'm just telling you that's not the law. But I've tried to help you out as much as you could, and I think paragraph 17 is a good stab at that. Yeah, and is it misconduct? So this is the problem is we don't have case law on bed bug cases, because if it ever goes to trial, which it usually never does, it usually gets settled, so it doesn't even go to trial, and any trial decision doesn't get reported to become a precedent. So we don't have any precedent cases. They have to go up on appeal to become really precedent law in Colorado. So we don't know what misconduct means. This law comes out of a fairly new law that I think the warranty of habitability went into effect, if I'm remembering right. I think it was 2007 or 8, which is relatively new. I've looked every year for bed bug cases reported in the cases, and there aren't any. So I don't know what the judges are going to say misconduct is. Is it enough that you have some proof that there were no bed bugs when they moved in, and then they just show up in the middle of the lease? Is that enough to show misconduct? If I were the lawyer for the tenants, I'd say, if that's all it took, the statute would have been written with the word, if it's due to the conduct of the tenant. Misconduct implies some kind of bad doing. So the question is, could you argue that it was misconduct because they were negligent in making sure they don't bring bed bugs in? The problem is you could be in a hotel, you could be at the Ritz and get bed bugs and bring them back, and you don't see them and no one knows till they, so it's a gray area. Law is not black and white. So you'd be arguing one side, they'd be arguing another. I'm saying as a business model, build in that you're gonna have to pay some money for pest control. So first of all, this is just the way our office works. CU's student legal service is very different, and everybody's different, but we are an advising office only. We rarely go to court with students. I will go to court with students on something that has me enraged, and I could give examples, but I don't think they're very relevant to the people here. So yeah, so we aren't likely to represent them, and they don't really need representation. So generally what we do is we look at everything. Sometimes I'll pick up the phone and call you. I've had landlords hang up on me. They don't want to talk to me, so I'm never sure if that's going to be helpful or not. But we help students figure out how to explain their dispute in writing and send you a dispute letter. And from there you can reply, and hopefully you can solve it. We can go to Patsy for mediation. We refer everything to mediation we possibly can. And you know, if it's intimidating, I like to be straightforward and just tell you how the law is. I don't skew it in favor of the tenant. That just doesn't feel right to me. I don't do business that way. And if anybody wants to call me, you're welcome to call me. I'll try to tell you what I can. I can't be your lawyer. I can't really give legal advice because I could be on the other side of something, but I'll be happy to steer you somewhere. Yeah, I would much rather help somebody solve something without suing, and that's the last resort for sure. So I want to make a comment about paragraph 18 and 19. So this was part of the humbling. How do I explain these insurance problems in plain English so that you know what's in your lease and you can explain it to a tenant? So I would absolutely encourage you to require renters insurance and to have them prove it up by giving you the declarations page. And you can tell them to ask their insurer to include you as an additional insured. There's no cost to that. And I can vouch for that. I had to do that for my daughter's renter's insurance and told State Farm, add her landlord as an additional insured. Oh, no problem. There was no additional cost to that. That helps protect you. So I would definitely do that. And I go further in that paragraph to try to educate a little bit as to why Colorado law will not hold landlords responsible for damage to property or personal injury unless there is an unreasonable condition that you knew of or should have known of and you failed to take steps to take care of it. That's the standard. That's a statute in Colorado law. It's really hard to prove that. So you're trying to educate the tenant that things happen. They happen all the time. You need to insure for it. The next paragraph about subrogation is that you need to insure for risk as well. So I imagine everybody has rental dwelling insurance. You should. And Colorado is behind the times. The other states have moved, not all the other states, but a majority of states have moved to this position that when a landlord buys rental dwelling insurance, the courts will imply that your tenants are additional insured, and your rental dwelling insurance company can't sue its own insured, so your insurance company can't subrogate and go back on the tenant if they were the one that caused the problem. That's the better result. It's what the majority of states are doing. Colorado isn't there yet, but Colorado will look at what was your intention as to whether you think your insurance company should be able to go back on this tenant and get reimbursed. So I feel very strongly that that section should be in your lease that says, we do not intend subrogation to go either direction. And it helps you too if your renter applies to his renter's insurance to get a claim covered, but his renter's insurance wants to look at you because renter's insurance thinks that you were at fault, you were negligent, you didn't fix that stair, you didn't fix the roof, your wiring was bad, so you caused a fire. The renter's insurance could come back on you as well. So I've written it so that there's no intention for subrogation to go either direction. And I've encountered a lot of landlords over the years where I've asked, how do you feel about that? And I've had many that say, I don't care about the tenant. If my insurance company wants to go back on them, they did something wrong, I don't care. But I see the tragedy on the other side of it. A typical example is water damage. And I have a section in there in this plain lease as well, telling tenants they have to keep the heat up to 65, frozen pipes and catastrophic water damage are real risks in Colorado. We see that all the time. Renter's insurance usually excludes water damage, which is not expected. My insurance agent didn't even know that, but it's true. Most renter's insurance excludes water damage. So scenario, you've told the tenants they shouldn't turn the heat down, but they're trying to save on bills. They do turn it down. They're gone for 2 weeks. There's a problem. Nobody's there to catch it, so the water damage gets even greater. Your rental dwelling insurance will cover it, but then they immediately sue the tenants for $20,000. And they might sue on a joint liability theory, the tenant who wasn't even at fault. So you've got these people, whether it's young people or poor tenants that are older adults that aren't students, whoever it is, it doesn't help you for your company to be subrogating against them. It changes their life completely to have a $30,000 judgment against you. It just isn't right, and you're paying for that insurance. Anyway, that's my soapbox. Feel strongly about it. You can fix it with one paragraph in your lease, and then the problem is solved. Great question. And would you be violating your policy with your rental dwelling insurance policy to do this? And I've not looked at every insurance, but I've done a survey of the ones I could get a hold of, the rental dwelling policies, like I have State Farms. It is allowed that you contract ahead of a loss to cut off the subrogation. You can't do it afterward. You would be violating your insurance policy if, let's say, the water damage occurred and then you sign a contract with the tenant saying, I don't want subrogation to happen. You can't do it after. You can do it prior to a loss in a lease. But you could always ask your policy, your insurance company that you have the policy with. But I would say no, it's not a problem. They don't care. They go after them and they get the judgment against them, and those judgments can be collected for lifetime. You have to renew them every 20 years if it's a district court judgment, but they do it. Collections companies, or that's how they do it. That's how they make their money. Yeah, they do it. No, if it's not in the contract, they have a right to do it. You have no control over what your insurance company is going to do later after a loss, but they won't have legal standing to do it if you have that paragraph in your lease. Yeah, I don't think they ask you for your lease, your rental dwelling insurance company. But For example, the State Farm rental dwelling insurance company just happens to be one I had easy access to. Read your policy. You can flip to the page that talks about subrogation, and you can look for this language I'm talking about that says it's fine to contract that away prior to any losses. It's in there. So you can either look at it yourself, you can talk to your agent about it. Comment is that some insurance companies might not add landlord as additional insured, but interested party. And sure, that could be possible that not all companies will do what State Farm. So you can put that in your lease in the alternative, you bet. The yellow sheet, I've tried to write that in plain English. I've highlighted all the laws that apply that I deal with all the time. There's so much of landlord-tenant law that is just reasonable approach. It's not all spelled out in the laws, but I've put the ones that do exist there down on paper. Great question. Does CSU educate our students about it? Off-campus life, they tend to be speakers in this program too. They do a lot of educating. We do our best to put the word out. I'm certain there are many people who don't get the word. I think we have 30,000 students. It just doesn't get out there to everyone, but we do a lot in our office, and yeah, but I think you have to assume, I think I have twin 20-year-olds, and they're really smart in certain ways, and there's so much they don't know, and they have no idea they don't know, and I don't realize they don't know, and so assume that you have to teach your tenants everything when they first move in. Yeah, that would be the way I would do it. But you are welcome to contact me. I'll do my best to help, and good luck.